Today we are trying to share with you some information about what's happening in Brazil regarding patent prosecution and what happens in the, I would say, real world when patentees want to enforce, have their rights in a faster way, in view of very recent decisions that we do have here. I do work at our patent prosecution department in Denmark for more than 20 years. And sometimes I jump to our litigation department and work with Natalia. We share for, 15 years work together with some clients. And I must confess, it's a pleasure working with you, Natalia. And also
I know.
And sharing with, I know, come on. That's funny. and we always are working together in very, I would say, tricky and interesting cases at our office.
Yeah. I always say that it's the best. Prosecution is great, but when prosecution gets exciting is when we join them. So it's the most exciting part.
Yeah. Good. And let's just start with the presentation itself. We divided such presentation in two parts. One is related to the constitutional challenge of patent term, which is a highlight that happened in the first semester of this year in Brazil. I must confess, it was the most important decision for decades in the patent era.
Yeah.
Because they ruled very important issues regarding patent.
Marc, would you speak closer to the microphone?
Like
I don't
this?
think I can. Yeah, I think so.
Better already.
Yeah, it's kind of far. I'm having trouble listening to you.
I'm sorry.
Okay.
I'll try like this.
Good.
And then we are going to discuss, show you a little bit about the patent prosecution in Brazil and how to better prosecute your cases with two types of fields. The first one in view of the constitutional challenge and what to do when you want to have your better patents, I would say, for using them and perhaps litigating with them. So that's why we are sharing here with Natalia this session, and we are trying to give you some hints about better prosecution in our country. Good. Let's try to inform you and show you what the constitutional challenge was. In Brazil, I don't know if you know, guys, but in Brazil, there was a minimum term for invention patents of 10 years. This means, can you see my mouse here or not?
Yeah.
Yes, good. Basically, what our law said was that from the filing date, if you have the grant before 10 years, your total term would be of 20 years, counted from filing, which is common to most of the jurisdictions worldwide. But if there was a big backlog in Brazil, examination backlog for patents, and our sole paragraph of Article 40 said that if your patent is granted after 10 years, you will have a minimum of 10 years term, which means your application is pending for 15 years, and after 15 years, you receive grant. So the total term of your patent will be of 25 years. This is just one example. And remember that the effects of patent terms, a patent in Brazil, they are backwards. They are ex nunc. And therefore, if somebody is infringing and committing something against your invention, for example, copying your invention that is protected under your patent, there will be damage during this time here. So the effects are not only here for the last 10 years, but for the whole story here. I mean, from publication.
Even though they will not be enforceable until the grant, after the grants, they are enforceable and the damages go backwards.
Exactly. So I said correctly, ex tunc, right?
Yes.
I've always mixed both of them. Sorry. Good. So basically, that was how it was working since '95, and this year things changed. On May this year, we had a ruling from the Constitutional Court, Brazilian Constitutional Court, stating that the Brazilian Federal Supreme Court ruling from 9 to 10, 12, from these 11 ministers, 2 of them were in pro of the sole paragraph that we just said, that patents should have a minimum term of 10 years, and 9 of them were against. So the minimum term does not exist anymore, and what we are going to explain to you right now is how this is working right nowadays in Brazil. So if your patent is granted after 15 years from grant, it will have only the regular 20 years term, okay? But nowadays, we do not have such big levels, for most of the cases, such big backlog, and this is not being applicable anymore in the majority of the cases. There are some exceptions for appeals, but this is not a rule nowadays. I will show you why. However, what the Brazilian Constitutional Supreme Court said is that for cases that were already granted, the minimum term will still remain. So if before the decision, let's say your patent was granted in March this year, you will still benefit from the minimum 10 years. However, for pharmaceutical and health-related products, you would not benefit anymore from this minimum of 10 years, and the patent term should be reduced if you have patents over 20 years counted from the filing date. So for pharmaceutical, if your grant was from 15 years counted from filing date, you would have 25 years, but you don't have anymore. The Brazilian, from June this year, the Brazilian Patent Office issued a very large number of new patent terms, new letters patent with new terms, reducing the term for 20 years. Of course, the majority of the patent.
So do you want to change I think the next slide, please.
I think his connection failed,
We
Natalia.
lost Mark.
Yeah, I think so.
Okay, so maybe I should share the screen.
Hello?
Now he's
Mark,
back.
are you back? Oh, you're back.
It was me. I thought it was you.
Yeah. So now it's good. So the thing is now, because this is so bad for pharmaceutical and health related inventions, how do you decide which inventions or which patents that were granted with an extended term will not have that extended term anymore? So what because the Supreme Court did not specify really what they meant. They said pharmaceutical and health related, but what's a health related invention? How do you calculate that? So what the patent office has done was this. You can talk about it, Mark, if you want.
Yeah, actually, I think we are just.
Perdemos todo mundo, gente.
Thaís, are you here?
Tá só Thaís.
Só tem gente da Dânima aqui.
Yes, no.
Yes, I'm
No,
here.
Thais is here.
Thaís é nossa, amigo.
Yes.
Ah, é?
É.
Ah, então,
Tem duas
realmente,
pessoas
não
aí
tem
de
mais ninguém
fora.
na sala.
Mas E aí, o que a gente está gravando
Pois
isso,
a gente fez o negócio com tanto carinho e não parece que ninguém
É.
sabe.
Bem, o que me disseram é o seguinte: a gente deve seguir com a palestra, porque as pessoas, a dinâmica é essa mesmo, as pessoas vão entrando e vão saindo.
Estão saindo.
Então, para a gente não parar a apresentação, porque senão eles entram e se não tem nada aí é que eles saem mesmo. De repente, eles entram no meio e veem que há algum assunto interessante, eles acabam ficando.
Entendi. Mas é melhor a gente parar, porque a gente...
Segue, porque está gravando.
Mas aí a gravação vai ficar disponível em algum lugar?
Sim, eles vão mandar para a gente depois.
Ah, tá.
Eles não vão disponibilizar lá para os clientes e para as outras pessoas, mas eles vão disponibilizar para a gente.
Tudo bem, então eu sugiro o seguinte, Natália, vamos fazendo de uma forma mais dinâmica aqui, talvez em inglês, falando só os bullet points, porque para mim não faz muito sentido a gente explicar em detalhes para a gente mesmo. Né?
Tá.
Eu normalmente converso comigo mesmo. Eu acho que é isso que a gente está fazendo aqui, né?
Já está acostumado, né, Marc?
Pois é. Okay,
então,
so
tá.
basically, let's part 2. Let's keep
Corta.
You have to cut this. I did it. So basically, what happened, what the PTO did, was to reduce the term for all patents that were sent to Anvisa because they were related to pharmaceutical inventions. I don't know if you know, but Anvisa is like the Brazilian FDA. There was a big issue regarding examination of pharmaceutical inventions in Brazil. For some time, we have double examination, one from Anvisa, another from Brazilian Patent Office. But for I would say a couple of months ago, this does not happen anymore because Anvisa.
That was a good change, right?
Exactly.
It had the bad change.
Fast, good change from Article 229C, modifying our laws stating that Anvisa should not be involved anymore in examination of patents. Anyways, so all the cases that went to the Brazilian FDA were cut to 20 years from filing date, and the big challenge was to see what are health-related inventions. Basically, what the Brazilian Patent Office did was to select some IPCs, and based on these IPCs, reduce those patent terms. There was a big discussion, for example, for veterinary inventions. And there's also bigger discussions for equipments. What's the extent of what should be interpreted as health-related invention? Health for animals? I don't think so, but and other areas. So basically, the Patent Office removed and changed some of those IPCs. And the tricky question is when those inventions are indeed applied for human health and for other areas that are not related to human health. So this is a very tricky situation nowadays. Do you want to add something, Natalia?
No, I was just
sorry, my connection, I have some delay from you sometimes.
Okay. So may I just say now, what do you do now, right? If you think your invention is not health related, but it is in one of those IPC classifications, and you have now a new term for your patent. So what we have been doing as a strategy is to file a petition to the Patent Office asking them to correct the term and cancel the office action, their decision that said that the term was now new and less than it used to be, because we don't believe that this is health related. That's not what the decision from the Supreme Court intended to do. So if it's veterinarian, or even though it's something that can be used in health, it doesn't necessarily mean that it's a health related invention. For instance, while my doctor uses lots of things on his office, but doesn't necessarily, even though a doctor uses it, doesn't necessarily means that this is a health-related invention, right? So that's what we've been trying to do. Also, the big thing now is for those other patents, for the pending patent applications. What do you do? Because your patent application is there, being analyzed by the patent office for 6-7 years, and pretty soon you're going to have a patent term that is less from that than 20 years from the granting, because if you can only enforce your patent after it is granted, and it takes more than 10 years for the patent office to grant it, and then you don't have that exception anymore, your patent is going to be valid for less than 10 years. So what do? What we have been doing so far, and it's been working, is that patent office has been, they have like a task force to try and change the backlog, okay, of the patents. It used to be so huge, and we thought this was impossible to do, but they've been doing. So they found a solution, and now this is actually going on. So what we have been doing is that when our patent application has been sitting there for too long, we file written mandamus to the court, the federal court, saying that the patent office is taking too long to decide this case, and because they're taking too long to decide this, we want them to decide it now. Okay, so this so far is like 100% positive. We have been the merely act of filing the writ of mandamus, the patent office has already been moving on, even if the judge doesn't ask them to do it directly. Just because we have filed the writ of mandamus, like they wake up and say, oh yeah, this case is very, it's been there for too long, and the patentee is very interested. So that's something that we would recommend a lot to do, because we have about 20, Brazil, we have identified about 20 something writ of mandamus, and in all of them, the patent office has successfully decided the case. So it is a very common, simple procedure to file, and it's something that we would recommend to our clients. Right, Marc?
Yeah, Natalia, it's one very important aspect to consider.
I'm not listening to you, Marc.
Oh my gosh, can you listen right now?
Yes.
This was working for this headphone is working for, I don't know, 2 years perfectly, but
Yeah.
I have
It's
to
time to change it.
Yeah. Anyways, what is important is that since there was a very big strategy or different strategies for the prosecution of patent applications in Brazil, considering the minimum term of 10 years, this changed. Now we have to pursue different strategies in order to obtain the patent in a faster way. But as you can see, as Natalia just said, Brazilian Patent Office in the recent past, in the last years, they faced a backlog. We are going to explain to you how they managed to reduce this backlog. And you can see nowadays, these are the applications. Sorry if it, since it's in Portuguese, because it's information from the Brazilian Patent Office website. This is filing date of the application, 2016. Okay, this is not so important, but as you can see, most of the applications are within 10 years from filing. There are exceptions here, let's say 2010, for example, where you still have applications pending at the patent office and they were not examined. So what Natalia is telling you is that we should focus on those pending cases that are at the patent office for a long time, because it is possible, for example, that these two applications here filed in 2002, they can be granted and to get a regrant already expired.
Yeah.
In this situation, sometimes the patentee has to have its patent granted because perhaps there is a licensing involved. There is some infringement conducted by third parties. So even if your patent will be granted and that at the same time, it's something odd, perhaps it's still important to have those patents. Okay?
Yes.
And paying annuities for them, it's not an easy matter. If you're still interested in your patent, you should consider to pay the annuities when they're over 20 years from the filing date, which is sometimes crazy. And this is not common worldwide because your case can be dead because you're not paying the annuities after 20 years, and you should perhaps have this local particularity of the Brazilian system in mind. Good. We forgot something, Natalia. Everything we're telling you about regular invention patents, they are applied also in Brazil for utility model patents. The difference is that utility models, as you may know, they are only for physical objects. They have to be novel. They have to meet inventive step, not inventive activity, inventive act actually, which is in Brazil, there's still a difference in the inventive step requirement with a difference between regular invention patents and utility model patents. And please don't ask me what's the real difference because this is a very hard answer, very hard question to be answered. In any event, the minimum term for utility model in Brazil is of 7 years counted from grant, and everything what you said also are applied for utility model patents. And if, for example, a utility model patent was for, I don't know, a needle for human treatment, it should have its term also reduced. But this are only very few cases that are in this regard. The same applies here. We do have some sort of continuation in part in Brazil, which is the certificate of addition. And terms should also be reviewed in view of the certificate of addition because it's like an accessory to the regular patent. Okay, so basically speaking, this is the examination procedure here in Brazil. First instance decision. Office actions in Brazil are published in an AIPPI Gazette, which have to be read every Tuesday. No letters are sent to the attorneys or patentees or applicants. Everything at the patent office is issued on AIPPI Gazette. If you do not follow those publications after years from the filing date, your case may be dead if you do not reply to those office actions. We have the allowance procedure and the second instance examination procedure when your application is rejected and the terms are even shorter, and this is examined by usually by 3 more experienced examiners before the Brazilian Boards of Appeal. And this is basically our workflow chart for examination in Brazil. But what you should also have in mind nowadays is in view of the court decision, in view of the change of the strategy, is that how you should amend your applications, when you should request examination, and how the divisional applications should be used as a strategy for obtaining further and better rights in Brazil. We are going also to talk a little bit about the fast track examination. Fast track examination are going just to list them, but we are not going to enter in details because our colleague Mariana, I don't know when her session is, but we can make a spoiler.
I know. Let me check. It's
and
her session will be at 5:10. Session
Sorry?
6.
Session 6. Okay. And she's going to explain for us a fast track examination in a very detailed manner. We are going to just tell you about some bullet points. So I'm going to jump the slide here because we can. you will have access to this material later on if you wish, but what's important here is, as common in our jurisdictions, you have to request examination within 3 years or 36 months from filing date. I think we can use this chart, Natalia, because this is more dynamic one. And
Good.
you have the filing here on the left, or this could be the filing in Brazil for regular Paris Convention applications, or this could also be considered international filing date of a PCT application. Anyways, within 36 months from the filing date, you have to request examination. Usually, we pushed the request for examination close to the deadline. But in view of what you can amend in Brazil, in view of the minimum term that we had, but perhaps this strategy has to be changed in some cases. Why? Because when you request an early, when you make your request for examination in an earlier stage, perhaps you can then have your patent in a faster way. Why? Brazilian Patent Office usually makes the organization of their examination of the applications based on the filing date, not on the date of the request of examination. So until now, the date of request examination should not have an influence in this term. But if the Patent Office is taking too long to examine your application, from your request examination, it takes, for example, 10 years or 12 years to examine your case, which is usually for odd cases, for very few cases in Brazil nowadays, you could perhaps request for patent term adjustments, which will be discussed in details by Bernardo and Luis Paulino at
Session 7 at 6 p.m.
This is almost a commercial, Natalia, here for the other sessions. Good, but anyways, you have to request examination till 36 months from the filing date. And let's say this blue circle here is your single claim, your single independent claim for, let's say, a device. Before the request for examination in Brazil, you can broaden your scope protection. This means remove features from your independent claim or independent claims. You can also shift your scope protection by removing some essential features and adding others, which is basically what you can do during the examination of patents or patent applications of other jurisdictions. But in Brazil, after the request of examination, what you can do with the scope protection is only to limit it. There's a big discussion in Brazil if this is correct or not. This is let's say, new interpretation.
And what is to limit it, right? The Patent Office has a very broad interpretation of what you can or cannot do after the request for examination. So this is a big discussion also.
Yeah, and this changed. The law did not change, but the interpretation of the law. There was a public civil action that had a decision in the first instance, the second instance. And I must confess, Natalia, until nowadays, I cannot understand anything about
it has
such
been
decision.
decided. It has been decided already. The thing is, there is an interpretation of what against which cases that you have to apply their interpretation. So that's the issue here right now. It's the last phase of the proceeding. So I mean, it's a big confusion. But the thing is, now we do not have, to this day, we do not have a decision from the Brazilian courts. We cannot say that the Brazilian federal court has an interpretation regarding what the Patent Office has been doing about their Article 32. Okay, we cannot say that. We even will encourage our clients, if they disagree with the Patent Office's interpretation, to file court actions against this very limited interpretation, because it's not legal. It is the patent office understand that something is more strict than what the law says, and that's not right. That's what we understand.
Yeah, and this is, let's say, a lack of decision or decision that we have from more than 10 years ago, let's say. It's correct, Natalia, I don't know exactly.
Yeah.
But the patent office has to do something in there between. And they had issued, they started issuing regulation this required starting in 2008. And the big ruling was in 2013. I think more than 10 years ago, they started ruling it. And it's been working like we are explaining to you right now. But anyways, so you can just shrink your scope protection after request examination. And let's say you have one device claim, independent claim in the blue circle, method claim in the yellow circle, two types of categories of claims in your application. Both of them can only also be have their scope protection reduced after request examination. The thing is, in your division application, the same applies as in the parent case. How you can divide your application in Brazil is by removing one of the categories into the division applications. And this is sometimes a very big confusion because patent applicants really don't know what decision of the patent office will be. The main case is still pending. Let's file a division application because for the dependent, for one of the independent category, in order to see if we can pursue better rights here. But anyways, in Brazil, in order to, after request for examination, you can only remove one of this is the interpretation of the patent office. You can remove one of the claims categories and put it in division application. You won't be able to add new categories that is disclosed in the original file application, but you still have to keep the same ruling and understanding of the parent case, which is sometimes very difficult to understand. And just one hint, division applications in Brazil can only be filed before the allowance report. This is very common coming from US colleagues, because in the US, after the allowance, you can file divisionals. In Brazil, it's not possible to do this. So our recommendation, if you want to have any type of division applications, make it at the earliest convenience. And when you have an office action from the patent office, submit the response of the office action together with the division applications. Or division applications or division application. Remember that division applications cannot be further divided according to the patent office. So we do have some decisions that there was a response to the office action. Right after was the examiner's allowance report, and the division was actually on the next day of the office action. The patent office does not admit it. Okay, so divisionals, potential divisionals together with the reply of office actions. This I don't know, red balloon here just explain what's inside the red balloon. Good. It's a nightmare to have patents in Brazil. No, or I mean to have faster patents in Brazil. Not. You have a very large possibility of having fast track examination in Brazil, which works a lot. I will say from the request at the patent office, you have the first office action within 4 months or something. And one important thing to add here is that in Brazil, until recent past, in order to start the examination procedure, it took a long time. Nowadays, it does not take this anymore. But when the examination really started, it was fast. You can see that our deadlines are very short to reply to office actions. Examiners are nowadays also on home office basis, and the production increased a lot. And we have been having examination I'll say every examination in Brazil, when it really starts, it's done within 6 months or something like this in order to have the rejection or allowance of your application. But basically, I told you, we won't get into details, right, Natalia, for fast track examination in Brazil. This is going to be performed
Because
by
Mariana will be
at
session 6
session
at
6
at 5:10 p.m.
5:10. But we do have PPH in Brazil. We started PPH with a pilot program, but nowadays we do have a full PPH program that is not limited to technical fields, to the office actions, but most of the patent office worldwide are within our PPH. We even have the multi-NI version of PPH with some of the offices. We had different PPH separated, and nowadays it's a bundle, and Mariana is going to explain you later on. Technology on the market, you're licensing them. They are on the shelves of the supermarket. So you can ask for fast track examination, which is quite important here in Brazil. And somebody is potentially infringing your application, send a warning letter, and based on this warning letter, you can request for a fast track examination. And we have more fast track possibilities also related to green technologies that is based on the WIPO Green Inventory IPC classes, but the Brazilian Patent Office has, I would say, a very wide interpretation of what is to be considered as green technology. But anyways, I told you that we would not, right, Natalia, get into details.
We'll not talk
here.
about this. Next slide, Marc.
I'm going to talk about rhythm mandamus, but you already told a little bit.
Yeah, I already told them because it has more to do with the constitutional challenge.
Exactly.
Right.
So we should put this balloon here before.
Yeah, we did it.
But anyways, it's a fast track possibility that we do have.
But just to say that the writ of mandamus can be filed even though it's not because of the 10. It's not so close to the 10 years. It's just because that the patent office has been stuck in one of the steps of the patent prosecution. So if it's been if it sit there for more than 2-3 years in the same level, then we may file writ of mandamus as well. Okay.
Exactly. Just to explain to you how the patent office faced their backlog, we have on the left side the formal start of the procedures in Brazil, when you have to request examination, etc. And visa, which is Brazilian FDA, as I told you, it does not exist anymore. This red chart here, I don't know, square. And here on the right side, we do have how the examination procedure works, whereby, I forgot to tell you, in Brazil, we do not have formal oral proceedings, but the Brazilian Patent Office, for special cases, they're open to hear some of our arguments in an oral way. We have been doing this in Zoom or Teams nowadays. They are quite open for that, but they do not express their opinion. It's like talking to somebody that does not make any type of reaction. They listen to your arguments. They don't get usually into details when listening to our arguments there, even in nullity action and things like that. But anyways, before the examination really starts, but the Brazilian Patent Office make a pre-examination, which is basically a report stating prior art that was cited in other applications of the same patent family, classifying them as X, Y, A, you name it, regarding novelty, inventive step, or just regular prior art that does not jeopardize the patentability requirements, and with the standard report. Based on this report, applicants had to file a reply within 90 days. If they do not reply, counted from the publication of the AIPPI Gazette, that is not sent to the applicants or attorneys. They are just published in the AIPPI Gazette. If you do not reply, case that. And what the patent office experienced is that okay, 30% of the pending applications did not have the reply to those type of office actions, meaning that examiners do not have to put their hands on around 1/3 of the applications, which make the whole process more efficient. And the the examiners could indeed have their focus for the applications that the applicants were still interested in having corresponding patent. So it was a nightmare. It started 2018, 19, 20. It's still running in 21, but with a reduced number. It was a nightmare for people that did patent prosecution. I had a little bit more of hair.
It was
Before
good.
that, it was good. Come on, it was a
It was
nightmare.
good for the whole country, right?
Yeah, exactly. But it's not a problem. But was it too much? Actually, too much in a reduced time frame. But anyways, it was interesting to have.
We have a new attendee, Munir. If you want to unmute your microphone and just
Our host has to do this.
Oh yeah.
Hi. Good to see you. Thank you very much. Just keep carrying on. I'm trying to catch up. It's a very informative slides. Everything is going well. Thank you very much. Just keep carrying on, please.
Okay.
And basically, what happened was a big, huge amount of work that the examiners had to do, that the patent professionals had to do in order to face it, and in order to put the applications from, let's say, 10, 15 years counted from the filing date, applications that were examined for more than 10 years from the filing date, to nowadays, I would say, for international standards, 4 or 5 years or something like this from the filing date. Remember, they usually examine from the filing date and not from the date of the examination request. Good. We don't have much time.
You don't have much time, yeah.
But basically, it's to show you, this is not very updated, but it gives you a very big scenario. When the pre-examination procedure started at the patent office, we had a lot of pending applications that were not examined. Cases decided were the green ones. This started, you can see it started before 2019 actually, but anyways, this was when the mid 2019, it was when the number of office action raised for 2,000 per week at the patent office. And this was a couple of months ago, it was in August. You can see that decisions, the green part of this, I don't know, pizza of this chart, it's increased a lot, showing that a backlog was reduced. We still have a backlog in Brazil around 40,000 cases that is being reduced. And I think this and last year backlog will be something from the past at a patent office.
So it means that the patent office effort was a success, right? For trying to eliminate the huge backlog that we had before.
Exactly. You and we go to international sessions. We not now we stay home, but I think we are going to next year going again to be overseas. And one big thing that I always listen, I think Natalia also listened to that, is, oh my gosh, what happens in Brazil with that backlog? We need faster patents. And I think will be in the past.
I remember that I always said, oh, it's getting better. And people would reply, oh, every year is getting better, but it's still the same. now we can, it's a big surprise, right? From when we get back to the conferences, like, look, this happened.
Exactly. Good. I think we are right on schedule here. Right, Natalia? If you want to add something here
No, it was a pleasure. And we are always, our emails are there. We are always open to any requests or doubts. We can clarify them regarding patents, patent prosecution, or anything related to that.